I think we have everyone. Thank you all for joining us. So this hearing is on class 14, which involves preservation of computer programs, including video games. My name is Kevin Amer. I'm Deputy General Counsel at the Copyright Office, and I just wanted to, again, go over some logistical items. We, on the government side, will pose questions and call on participants to answer. We would ask that you please, if possible, use the raise hand feature on Zoom, and we'll call on you. If for whatever reason that isn't working, feel free to just raise your hand and we'll call on you that way. We have a number of topics to cover, and so we would ask, as always, that you please limit your responses to the topic of the question asked, and to keep your comments relatively brief. Secondly, today's event is being live streamed and it's being recorded and transcribed by a court reporter. The video and transcript will be posted on the Copyright Office. Helpful.
Hello, this is the court reporter, Mr. Finally, we seem to be losing you. You're okay now, but we lost the past maybe 10, 15 seconds.
Okay, does this sound okay?
Yeah, I think you're good now. It was maybe just a momentary slowdown.
Okay. Finally, as we've indicated, on Wednesday afternoon, we're going to be having what we're calling an audience participation session. For those who would like to join that session, you can sign up using the link that is now provided in the chat. And on Wednesday afternoon, you can join that session using the same day's link that will be available for the hearings on Wednesday. So as I said, this hearing is on class 14. I would like to first invite those of us on the government side to introduce themselves. So could we start with Ms. Rubel and Mr. Riley?
Good afternoon, Jordana Rubel, Assistant General Counsel.
John Riley, Assistant General Counsel.
And Mr. Zambrano.
Thank you, Mr. Mayor. This is Luis Zambrano Ramos. I'm a policy analyst in NTIA's Office of Policy Analysis and Development.
Great. And now I would like to invite the participants to introduce themselves. So let's start with the proponents. So Mix Albert, Mix Teitler, I hope I'm saying that correctly, and Ms. Woodall.
Sure. Kendra Albert, I'm an attorney with the Cyber Law Clinic representing the Software Preservation Network.
Maisie Teitler, I am a teaching fellow in the Cyber Law Clinic representing the Software Preservation Network.
Madeline Woodall, I'm a student attorney at the Cyber Law Clinic representing the Software Preservation Network. Thank you.
And Mr. Band.
Hi, I'm Jonathan Band representing the Library Copyright Alliance.
Dr. Ruberg.
I'm Dr. Bo Ruberg. I teach digital media at the University of California, Irvine.
And Dr. Lowood.
Hello, I'm the Harold C. Hobach Curator at Stanford University. I'm responsible for the film and media collections and the history of science and technology collections.
Great, and now I would invite the opponents to introduce themselves. Let's start with Mr. England.
Hi, this is Steve England of Jenner & Block here for the Entertainment Software Association.
And Mr. Williams.
Yes, Matt Williams of Mitchell, Silverberg, and Nutt for the Joint Creators and Copyright Owners.
Great, thank you all for participating. So to start off, I would like to talk about some of the scope of offsite access that's being requested here, because there seems to have been some dispute in the comments about what actually is being contemplated. So I'd like to start, if I could, with the proponents. I'm hoping that you could provide just a general overview of what sorts of offsite access is being contemplated by your request. In particular, are you talking about providing individual copies of programs, streaming, and any sorts of limitations that you're envisioning with this petition? Mix Titler.
Yes, I'm happy to answer this question. So we believe that there are a number of non-infringing uses that could be contemplated under this exemption. For instance, controlled emulation for researchers and scholars to interact with and research obsolete games. Also, controlled screen sharing of materials for remote learning classes. A number of uses that would be lawful under both 107 and the Teach Act that could be carried out under this exemption.
Yes, Mix Albert.
Just to second what Mix Titler said, we didn't lay out a clear sort of list of what are potential authorized offsite accesses, methods of access, because we believe that libraries and archival institutions need the flexibility to determine what is the best sort of non-infringing use for their particular work and for the particular circumstances. That might include in certain cases making an emulated version available. It might in certain cases include loaning out a work. They ultimately, video games and software more generally is a sort of it's a broad category. There's a lot of different potential sort of uses and types of works. And so we don't believe that writing in particular restrictions into the exemption would be an effective way of resolving that lack of resolving the sort of individual needs of archival institutions.
Now, as you know, one of the concerns, obviously, that we've heard, and I'm going to obviously give the opponents a chance to address this, but one of the concerns we've heard is that, as drafted, your proposal does not include any of the limitations, in terms of number of copies that can be distributed. It seems to me that one analog to your proposal is 108E, which provides some opportunity to provide individual copies, but it's limited to single copies, and there's language in the statute about preventing systematic reproduction and distribution. So I'm wondering what your response is to that concern. Yes, Mix Titler.
So I think 108E is a helpful analog here. 108E does have a user end number limitation, but it doesn't actually impose the same numerical limit on the library end. And so if we were to have analogous restrictions here, which again might be appropriate in some instances, but in other instances, fair use and the Teach Act might cover additional copies, that restriction would be applied on the user end rather than the library end.
Yes, Dr. Ruberg.
I just wanted to speak briefly from the academic perspective. So in terms of number of copies, to give some context, I often teach video games in quite large classes. So when we're talking about undergraduate students, I teach a class on digital media and society at UC Irvine that is 350 students large. So it's just to give you a sense that often for really core educational classes that teach literacy in digital media, we actually need quite large numbers of, again, authenticated and official students accessing the material.
Okay, so I wanted to follow up on one point that was made, which is this idea that this single copy limitation applies to the end users, but not, in your view, necessarily to the I guess the preservation copies. Is that what you're saying? So just so I understand, so when you talk about making copies available off-site, are you talking about end users, students, researchers, et cetera? Or are you talking about people who would be doing some of the preservation work, or both? Yes, Ms. Tytler.
I think we're primarily talking about users. So with 108D and 108E, those copies are meant to preserve the traditional scholarly right to conduct research at home with one's scholarly materials that has been enjoyed by libraries and their patrons for centuries with traditional materials. While there might be some cases where archivists could conduct work offsite remotely that would be fair, I don't think that 108D and 108E specifically would encompass those uses. Does that answer your question?
Partly. So in terms of what your proposal is trying to get at, you're trying to implement something analogous to 108D and E that would provide for the equivalent of what's provided for in those exemptions.
Our view is that there are a number of uses that are legally permissible that are not currently allowed because of the on-site limitation that was put in the previous rulemaking. That includes uses such as analogs to 108D and 108E, but might also include some additional uses that would be fair under a case-by-case fair use analysis, which again is very fact-specific and very individual, and is the reason that we believe that this broader language that would allow libraries, which are very risk-averse institutions that are accustomed to making these kinds of decisions about their traditional materials, to analyze and decide on an individual case-by-case basis what would be appropriate.
Max Albert?
Just to second what Mix Tytler said. So I think that, yes, we I could imagine certain circumstances where a 108D or a 108E style sort of loaning out, sending a copy would be appropriate. But for lots of video game uses, that's just not going to be a useful idea. Like, let's say, oh, great, like you get this floppy of this 1980s game, and we'll send it to you, right? This individual copy. Well, if I'm a scholar or researcher, like, great, I now have this copy I can't use. So there may be circumstances in which something like sort of emulation as a service or other types of access are just going to be more appropriate to the particular work. So we didn't want to limit it to the kinds of restrictions that are in 108D and E, because we don't think that that's necessarily consistent with the different ways in which folks need to use these works, including what Dr. Ruber talked about sort of access for teaching. Okay,
so to follow up on that, so I think one of the, and I want to bring in the opponents too, but one of the concerns or maybe points of confusion seems to be that the current language talks about preservation, right? And so the current language in some respects tracks section 108C, although not entirely. So I think there is some question about if you're asking for an exemption that covers these additional activities, teaching and scholarship and so forth, whether that would need to be that would need to be spelled out more clearly in the language of the exemption, because those things aren't necessarily limited to preservation. Yes, Dr. Lowood.
Yeah, maybe it would help if I said a few words about why libraries engage in preservation in the first place. Surely there's many benefits to that, many cultural heritage reasons for doing it and so on and so forth. But in terms of our core mission as university-based libraries and archives, we support instruction and we support research. So the preservation activity should not really be thought of as separate from provision of access. It's really the reason that we expend resources to in these expensive projects to preserve software of various kinds. We do it in an order that classes like Professor Ruberg's can be conducted, and that researchers who come to us for access to historical materials can be served.
I wonder if either Mr. England or Mr. Williams, you wanted to speak to the concern you raised in your comments about, this apparent lack of restrictions on the parameters of the offsite access.
Sure, I'll take a stab at it, and Mr. Williams may want to as well. But first, I want to be clear that video game companies support legitimate preservation by responsible preservation organizations. But like you, Mr. Emmer, I think I've kind of struggled to figure out exactly what it is that's being proposed here. At the original proposal, regulation that didn't have hardly any limitations at all on the use beyond that have to be a library and archives and preservation. And more the reply comments suggest some limitations that possibly the proponents would be willing to accept, but they aren't very limiting at all. And this may not be the time to get into that, but I'm happy to do so. But then today at the panel, we've been talking about distribution of copies. And I didn't understand from the comments that were filed in writing that distribution of copies was even something that was in the cards here. And not obvious to me that that really works, because video games and video game consoles tend to have interoperable technological protection measures. And so simply passing out copies of games doesn't necessarily mean that they would be playable on consoles, unless this is also about allowing all the students in a class to hack consoles. If this is focused on emulation and it's focused on scholarly purposes, I think the regulation doesn't do it. And it's also kind of confusing what the proposed regulation says, because the initial comments from the proponents marked up clause 12.2 of the regulations, while their reply comments marked up 12.1b of the regulation. So it's two different paragraphs of proposed regs. But either way, there aren't a lot of limitations here. And so I think the office's task is to analyze the full possible scope of what is permitted under any particular regulations under consideration. And I think, based on what we heard so far, it's one that would allow any public library in America to engage in circumvention of TPMs without a limitation to university libraries or research purposes or much of anything else. And if you then apply your fair use analysis to that, I think you conclude that there are lots of uses that aren't the kinds of uses that the proponents are talking about.
I'd like to jump in, and maybe it would be a good point here to talk a little bit more about the concept of controlled emulation and what is actually happening there. I think that the record can kind of use a little more discussion on that point, because it doesn't look like the exception is looking for an emulation or controlled screen sharing language in the exemption itself. So if someone would talk about where copies are made and what other 106 rights are implicated by that, it would be helpful. Ms. Albert, I see your hand is still up. Would you like to address that?
Sure. I think I can understand that there might be some lack of clarity on what we're proposing. That's merely because we're trying to accommodate the wishes of the Entertainment Software Association and the joint creators in terms of adding additional restrictions to the exemption that we think will do their best to minimize the harm on preservation institutions while preserving the interests of video game makers, and to harmonize the eligibility restrictions across the two software preservation exemptions, or two of the three software preservation exemptions, which we know is a subject of much confusion. In terms of the controlled emulation or the 108 copies, the purpose is to allow archival institutions in the way that meet the eligibility criteria proposed by the Copyright Office in 2017 as part of the discussion document, to do what they do with all of their collections, which is make a determination about what an appropriate use is given the rights of the copyright holder, and engage in the and then engage in those uses. So some circumstances, those might be controlled emulation uses. And I think Dr. Lowood can talk a little bit more about how exactly that works. But the point is that specific restrictions around like it's only good for this thing is totally inconsistent with how archivists and preservationists actually preserve video game works. And the core problem here is not that the works aren't being preserved, because there's actually no ability, and there's no ability for scholars to access. So I think that, you know, if the Copyright Office thinks it's appropriate to include the sort of, I think it's 108D style language around notice of access to the work, or notice that access to the work is for no purpose other than private study, scholarship, or research, in order to offset some of the concerns about sort of general online access to arcades. I think that, you know, we as proponents would be okay with that. And we obviously are suggesting importing the eligibility requirements that were part of class 14A, the non-video game class, to 14B. But I'll let Dr. Loa talk a little bit about the controlled digital emulation space, because I think he's better equipped to talk about the realities of that.
Okay.
Yeah,
okay.
I'll go ahead and do that now, if that's okay. First, I should say controlled emulation is something that's being tested now. There aren't a lot of actual services that have been stood up. In the academic library and archives world, the idea behind controlled emulation is that collections available at one institution could be made available to authenticated researchers or to students at a home institution, or possibly at other institutions as well. Again, these would be authenticated users. It's an online system that allows for that. The situation with rights for access is a bit of a stumbling block right now. We under the current regulations, we feel like it's going to be very, very difficult to do that. But you know, Stanford, any major library that is involved in creating a service like this is going to be very attentive to the rights holders and their interests. We're not going to be putting anything up on the open web. This will be a closed system with authenticated users, and pretty much restricted to the researchers and students, you know, the groups that we've mentioned earlier.
And can you explain a little bit more about, you know, where the copies are in emulation? Because I'm not entirely sure I follow, you know, is the operating system being emulated? How does that work with the game, for example? I just think you need to walk us through a little more slowly.
Yeah. So, you know, we have a software collection at Stanford. Say we pick a title from our collection to make available through emulation. At Stanford, you know, at the holding institution, someone will put together a kind of a package which involves the environment that's needed to run that software. So if it's software that uses an early version of DOS, for example, that will have to be accessible to that system, and that will run at Stanford. A user at UC Irvine, where Professor Ruberg is, would make a request to us, would be authenticated, and would essentially have that available through the browser in kind of a streaming fashion to them.
Let's go to Mr. Zambrano, who I think has a question, and then I'd like to move on to talk about Section 108 in a little more detail.
Sure. Thank you, Mr. Amir. And this is for proponents, and maybe this is for you, Dr. Lowood. Could you elaborate a little bit more on the security parameters that are used when you're sharing some of this information off premises? You mentioned a closed system, authenticated access, but I was wondering if you could talk a little bit more about that. Are there any kind of anything that guides you to develop that security, maybe from the software development world? Is there anything out there that could explain how this security process works? Thank you.
Should I go ahead and just answer that? I will do that. So first of all, let me clarify. I'm not part of our IT team in the library. I'm not the person who's going to be designing the system, but the way it's going so far with our testing and with our projects to develop this is it probably would be a single sign-on, like you would have at any university where you would use your university credentials to sign into the system to gain access to the node at your university, and that would be the way it would be delivered. So I expect that we would require authentication, something like that. I can't say that, now that it's going to be the usual sort of single sign-on. So single sign-on would be basically your university username and password would get you into that system.
Mr. England, did you want to respond quickly? And then I do want to move on to the next topic.
Just a couple brief points before we move on to the next topic. I mean, first, the discussion of controlled emulation is interesting and to a certain extent, perhaps even comforting, but none of it's in the regulations. So there's no limitation to universities or researchers or students or authenticated users or anything like that. It's that is a very different proposal from the proposal that is on the record. Second, simply should observe that college students are important consumers of video games. And so merely saying that somebody is a student at a university who has been identified as being enrolled at the university and ought to be able to access emulation is not a comforting message. Yeah, I think if the proposal is that these are authenticated students that are doing a project on a particular game, it's a different proposition. You can, if you wrote a regulation to that effect, you could analyze it. But again, merely saying that somebody is a university student ought to be able to play games through an emulator is not something that sounds like it would be a fair use.
Okay. So I see some hands up, but I do want to ask another question about, I think it might be helpful for us to sort of understand what your views are in terms of what Section 108 currently allows and does not allow, and to what extent fair use or something else may need to come into play to fill in any gaps. So, I mean, I'm looking at Section 108, and as we've talked about, there is Section 108E, which provides, does provide an exception for libraries to provide individual copies that become the property of the requester if a market check is performed and a copy is not otherwise available. Now, 108I excludes audiovisual works. So it seems to me that if we're just looking at 108 and we're talking about making individual copies for users following a market check, you would need to look to some other, you would need to look to fair use or something else to cover video games. But I'd like actually both sides to address that and see if they agree. Mix Tytler?
Yes, I'm happy to speak on this. So to your point, 108I does exempt audiovisual works from a number of the 108 provisions, including 108D and E. As I mentioned earlier, the spirit of 108D and E absolutely encompasses the uses we're talking about here, that traditional right to scholarly research done at home. Moreover, in the 108 report that the Copyright Office put out a few years ago, the office clearly indicated that the requirement of operating from a physical premises for 108B and 108C is no longer functional for audiovisual materials. And we believe that that is absolutely applicable here. I'll also add that a number of the synchronous and asynchronous online courses that we might talk about that would happen under this exemption would be encompassed by the TEACH Act if people were engaging with portions of material. And I will maybe suggest that my colleague, Ms. Woodall, can speak further to the applicability of fair use here.
Yes, Ms. Woodall.
Absolutely. So, well, 107 can fill the gaps left by 108 here for uses including research and teaching, which would not be included under 108 currently. Our argument laid out in both both our long comment and a reply that these are transformative fair uses still holds and is actually it been strengthened since the Google decision made earlier this month that recognizes teaching and research as transformative paradigm purposes that fulfill fair use.
No, I understand that. I'm sorry to interrupt. And we're going to certainly get to fair use, but I just want to kind of start from, I want to put fair use to the side for just 1 second and start with, see if we can sort of reach agreement on what may or may not be permitted under section 108. So Mr. Williams, could I bring you into this discussion? Do you agree that if a library has a collection that includes software other than computer games, they have some right under section 108E, provided a market check is completed, to make and distribute individual copies of those works to users?
Thank you. So just to make sure I understand your question, you're asking about software other than video games that would not simultaneously be an audio-visual work?
Right.
Right. So on 108D and E, my understanding of 108D is that it only applies to portions of specific types of works, and that probably is not the space in which we're living for this discussion. With 108E, I think it applies to instances where there's an actual request by a researcher, not a proactive policy that's put in place to try to create replacement copies or preservation copies of the computer programs. So as I've understood the proposal, and my understanding was consistent with Mr. England's, that they weren't really looking to distribute copies of programs so much. You'd be living within the 108B for unpublished materials or 108C for published materials, and that's limited to on-premises access. So I guess that's a long way of saying, I think the answer to your question under 108E for a computer program that is not also an audiovisual work would be that in some instances they could distribute a copy on a request from a researcher.
Okay, thank you. Dr. Ruberg?
Hi, so I just wanted to bring up what looks to me like an equity issue, which is about differences across different areas of media, different things that we might study. So I'm a scholar originally in literature. My PhD is in comparative literature. And I have colleagues who still teach in literature who have access to these materials that they need for their scholarship, for their teaching. I mean, you can reach out to a library, to an archive, ask for something obscure, get a copy of it. Whereas for us teaching video games, it's really just completely night and day. So we don't have access to things to study, we don't have access to things to teach, and video games really are just as crucial as forms of culture, as forms of art, as something like literature. And I also want to clarify just very quickly to respond to Mr. England's question about students going on playing video games for fun. The types of games that we are talking about, the types of games that I'm talking about, are not primarily contemporary big games that our undergraduates are playing, for recreation. These are artistic games, historical games, small experimental games. These are the things that our students and our scholars need access to.
Thank you. Mix Albert?
Well, I just wanted to take a second to point out that the 108, I believe 108B and C, although it says premises, it doesn't specify physical premises in the way that the exemption, the current rounds of the exemption do. And I think there are certainly institutions that understand that as premises being the sort of broader authenticated space in which users can work in. So I think even if you were putting the non-video game software under 108 B and C, I don't think that necessarily supports a restriction around physical premises.
Okay, I wanted to ask one other question about 108. So in our 2018 recommendation, we in recommending the exemption for preservation of computer programs other than video games. We did focus on 108C and kind of highlighted the fact that it expressly prohibits the distribution of digital copies outside the premises of the institution. And as you note, McAlbert, it doesn't, the exemption refers to physical premises. The statute just talks about premises. What should we sort of do with that? I mean, I take the point that the current exemption doesn't exactly track 108. It allows, it's not limited to 3 copies. It includes museums and so forth. But what do we, if we have a sort of express prohibition in 108C, I wonder what your view is as to, how we should address that. Yes, McAlbert.
So I think that it goes back to the reasons why the Copyright Office didn't accept some of the other limitations that are present in 108C, right? Not restricting the exemption to, damaged, deteriorating, lost, stolen, or format obsolescence. And in 2018, we discussed extensively why format obsolescence is not the right framework here. And I think that this speaks to the need to sort of that the Copyright Office has written about in its discussion document to sort of update to move beyond the sort of textual context of 108C to sort of accommodate the realities of the needs of scholars and institutions. And, I don't mean to belabor it, but clearly like the COVID pandemic has accentuated the need to no longer be required to have off-premise, to no longer be restricted to particular physical on-site premises access. So I think that, whatever the reasons why we chose not to focus on Section 108 in this current round of rulemaking is we think that, fair use provides a much more robust, broad way to accommodate the types of uses that archival institutions have to make of these works in order to actually serve their users in the way that is equitable in the ways that Dr. Ruberg was talking about.
So, I mean, I'm trying to sort of address, the concerns about sort of unlimited copies and so forth. So from your perspective, is it appropriate for us to consider a framework similar to, if we're talking about any off-site access, is it appropriate for us to look to 108E, which is a much more sort of, confined exception? It does allow for offsite copies upon the request of users after a market check has been performed. Is that something that, kind of moves the ball towards facilitating the types of uses that you're interested in?
I'm assuming that's for me. Yes, I mean, that's why we, in our sort of the language we incorporated in order to address the ESAs and the joint creators' concerns, incorporated some of the 108E language, right? The no notice that that access to the work would be used for any purpose other than private study, scholarship, or research. What I would want to caution the Copyright Office against is limiting the sort of uses to those present in 108E. We think that the 108E style restrictions are totally reasonable, and that's indeed why we said we'd be willing to submit to them if the Copyright Office thinks it's appropriate.
Okay. Oh, yes, Mr. Williams.
Yeah, I would just say quickly that, as you mentioned, 108E does not apply to video games, does not apply to audiovisual works, and so you'd be going outside of 108. And the other thing that I have an issue with using the language that the petitioners proposed, although I do appreciate them putting it in, and I understand that it comes from the statute, is the security language about just not having notice that someone essentially is going to misuse these copies. Doesn't go far enough for my liking. It basically, unless you proactively go out and try to ask someone to admit that they're going to do something other than research, the language doesn't have much teeth. So it's hard to imagine a situation where someone who's a beneficiary of the exemption wouldn't be able to qualify under that language. Someone would need to, show up wearing a T-shirt that says, I want to do something more than research or something like that potentially. So I think much stronger language would be needed there.
Okay, I'm gonna give the folks with their hands up a chance to respond, and then we're gonna, I think, move to the next topic. So let's go first to Mix Titler.
Yes, so I'd just like to raise the point here that these types of limitations have worked perfectly well in other rights holder contexts. I mean, books, all traditional publishing materials have been able to be subject to these types of limitations without bringing about the downfall of an industry. I also think it's appropriate to add that libraries make these kinds of decisions constantly. They are attuned to what scholars are coming in to study. They are aware of the types of decisions they have to make to comply with copyright law. We're not talking about people who are particularly not risk conscious. Libraries are very conservative institutions that care about compliance. And I really think it's unrealistic to suggest that a library would go out here and make copies available where there might be bad actors who would take advantage of them. It really flies in the face of what they do already every day to make traditional works available in this way.
Mr. England?
I agree with everything Mr. Williams said a few minutes ago, and I would just like to put a little bit more gloss on it, that the proponents here have chosen one of the weakest parts of Section 108E is their offered compromise here, that there's no notice. But the concept of notice isn't very meaningful if a public library chooses to put emulated games up online for a public audience, as their proposed regulations would seem to permit. At that point, nobody's going to provide notice that when they go online to the library's website and play the game. And they have omitted from their proposal the limitation that someone mentioned a few moments ago, the requesting language. That was language crafted back in the 60s for a very traditional interlibrary loan model, where a researcher manifests himself to a librarian and I'd like to get this book, a copy of this book from interlibrary loan. And in that case, perhaps the absence of notice coupled with that human interaction of the request is perhaps a reasonable limitation of the statutory language. But here, we don't have that limitation. So the proposal would permit a library to make a game available for the public. And with that, the notice limitation is not meaningful.
Mix Albert?
So I want to note that I think that I'm not sure, and maybe this is my mistake, but Mr. England and Mr. Williams have overlooked the fact that there are requirements built into the eligibility criteria of using reasonable digital security measures. That's the thing we're choosing, where we think that it makes sense to take from 14A to 14B. So without writing, it's written into the definition of an eligible institution that eligible institution has to include appropriate digital security measures for the particular works at issue. And this is building on, again, the Copyright Office's discussion document from on Section 108, where the Copyright Office specifically says, hey, it doesn't make sense to require particular specific security measures. It in fact is we want that would be an overly burdensome requirement, but what we want is for libraries, archives, museums to be able to make the appropriate decision about the types of security restrictions. So I think that if an eligible institution has to use reasonable digital security measures, right? So that already says that Mr. England and Mr. Williams' parade of horribles, where the public library is sort of making these games available for free. Well, unless we think that is a reasonable digital security measure, and I think it's clear that Mr. England and Mr. Williams don't, right? Then that's not an eligible institution under the exemption. So I want to be really sensitive to the concerns that the joint creators and the ESA have. I understand that this is a space where there are a lot of competing, difficult decisions to be made. But I think it's kind of like, as my colleague Nick Teitler said, libraries make these decisions all the time, right? And part of what we're doing is just trying to preserve the same flexibility that the Copyright Office mentioned in the Section 108 context, in order to allow them to do so. But Dr. Lowood is much better positioned to speak to that than I
am. Thank you. Yes, Dr. Lowood, and then I'd like to ask another question.
Yeah, just a little bit of context, maybe information to support what Nick Albert just said. My experience is that academic libraries are pretty conservative in this regard, quite risk averse. If you look at our catalog, there's very little from our collection that is available in the open web to anyone, in other words, without restriction, without authentication. And in every case, those items are available because we have explicit permission from the rights holders. We're involved in a project right now regarding thousands of digital objects that we created as preservation measures to contact rights holders and see if we can secure their permission to make things available in the open web. And if not, only research access will be provided in those cases. So I just sort of want to temper the idea that we're, that our goal in this is to provide, unrestricted access to everyone. That's not the case at all.
Thank you. So my question before was, just limited to 108. So I would like to now sort of turn to fair use. So it seems to me that if you're going to include video games, some degree of offsite access to video games, you would need something other than 108 as a basis for doing so, given 108I, which excludes audiovisual works from the exception under 108E. So for proponents, and Ms. Woodall, I apologize, I cut you off before. I don't know if you wanted to jump back in here, but I'd like to hear your sort of, best case, what for the proposition that fair use under current law might extend to some level of offsite access for video games. Yes, Ms. Woodall.
Yes, of course. So fair use under current law, which is currently developing, and we've actually seen the most recent Supreme Court decision on transformative uses of software earlier this month. I think the same logic can be transposed over to video games, where although we are using, or although a researcher, preservationist, or educator might be using the video game or software for its exact same use as designed, as long as it's being used for an overarching transformative purpose, it can be, the purpose weighs in favor of fair use, as it did in the Google v. Oracle decision. Breyer specifically noted that teaching and research are paradigm transformative uses, even if the software is being used for a similar use or a similar context, so long as that overall use is transformative. Teaching, research, and scholarship add comment and critique, which are fundamentally transformative. Our brief goes into much greater detail about other aspects of history and research that are transformative, but effectively these uses we're seeking to allow are all transformative and have very minimal to no market harm, as these are out of commerce works we're talking about.
Thank you. Mr. Band?
So it seems to me that the only issue here really is, I guess, the fourth factor, right? I mean, because we already have an exemption that allows on-premises access. And so what we're trying to do here is get off-premises access. And so the only difference really between on-premises and off-premises conceivably is some potential harm to the market, right? Otherwise, it's all the same. And so that's really the issue. The only issue to really focus on is there somehow a much greater threat to the market of the rights holders by virtue of off-premises access? And the answer here is plainly no. I mean, part of it is because the nature of the works we're talking about, we're already talking about out-of-commerce works, so that already diminishes significantly the risk. But also, you know, let's be real. You know, if I can go into the library with my laptop and have access to the video game on my laptop in the library, how much less of a risk is that than if I could do the same thing from my my apartment or my dorm room? I mean, either way, there's going to be adequate authentication and security, or there isn't. And we've already heard that that's a requirement that there is now. There's been absolutely no showing that somehow this has been abused, that this has let open some floodgates. And so given that, there really is no difference. And so we're, this is to some extent a little bit of a, how many angels can dance on the head of a pin? There's really not going to be any appreciable difference to the market. Either our security measures work or they don't. And if they do, then it doesn't matter whether it's in the in the library or outside the library. Either way, it's the same.
So the current exemption says video games applies to video games solely for the purpose of preservation of the game in a playable format by an eligible institution. And one of the conditions is that the video game is not distributed or made available outside of the physical premises of the eligible library. So I think a question is, and I take your point about, already the exemption already providing for some degree of on-premises access. I think a question is, how is this proposed exemption related to preservation, which is obviously the focus of the current exemption?
Well, I mean, preservation is the reason the one is circumventing, right? I mean, you need to you're circumventing in order to preserve the work, and then the question is, okay, now having preserved the work, what kind of access is permissible? And is it only on the premises? Is only researchers on the premises, or can a researcher from from an apartment down the road, can that researcher also have the same access? But the underlying purpose of the initial circumvention is the same. I mean, it's for purposes of preserving the work.
Dr. Ruberg, I think maybe you had your hand up first. If not, I apologize.
Thanks. So I just wanted to provide an example that speaks to Ms. Woodall's point about transformative use, fair use, transformative works, and also this question of preservation and access. So to give you a sense, so a lot of the work that I do is on diversity and LGBT issues in video games. And what I do as a scholar is I'm actually looking back at games across history to find the things about them that are related to LGBT issues and to inclusion that may not be immediately obvious. So I'm not necessarily just looking at games that have, LGBT people in them. I'm trying to unearth, who has worked on these, what messages are in them. So there's a deeply transformative purpose to this kind of cultural work on games that actually shifts what we think we know about them, shifts the conversations around them. And for example, I was working on a project where I really needed access to materials that were at, there's a museum of play in Rochester, New York, which I'm in Southern California. That is not an easy trip to make. And if I had been able to have remote access to those materials during my process, I could have done that transformative work because they would have been preserved. So I just want to second this idea that the preservation and the access for me as a scholar are inherently linked.
Mix Albert?
Sure, I had two quick points I wanted to make. One is just to build on Ms. Woodall's point about Oracle v. Google. And I think that the other piece of language that came out in that decision, so it's after our filings, that I really want to emphasize is Justice Breyer's discussion of the public benefit in the fourth factor, which I think goes to Mr. Band's point about sort of like what is the debate about here, and how even if there is some sort of market harm, right, which there is no evidence in the record that the preservation by the types of eligible institutions we're talking about here is causing any kind of market harm. But what I will say is that Justice Breyer very explicitly talks about weighing the public benefit and the importance as part of thinking about the fourth factor. And I think that's worth emphasizing here, as Dr. Ruber talked about that important public benefit. The other thing I wanted to flag was, I think that Dr. Ruberg and Dr. Lowood can talk extensively about the relationship between preservation and access, but I wanted to point the Copyright Office back towards a part of our original briefing where we actually talked about how in order to sometimes get funding for the kinds of preservation, the expensive kinds of preservation that we're talking about here, institutions have to make these kinds of work accessible to outside researchers, right? Or to sort of populations who are affected by them. And we actually heard stories since we submitted our original testimony that there are certain grant committees that will look at a grant that doesn't allow for sort of access to the relevant researchers, not by going to the site, but sort of more generally, and will give you money. So if software preservation is inherently tied to these sort of on-site premises restrictions, this work isn't going to be preserved. The way this has to do with preservation is because the limiting of the access to these works limits the types of works and the works that are getting preserved.
Mr. Williams?
Thank you. On Oracle versus Google, we had some discussion of this last week, and at least my reading of it is it's much narrower than the space we're discussing during this particular hearing. It was dealing with uses of functional API software, nothing close to a video game, an audiovisual work. And I think Mr. Band agreed with that last week, although maybe I'm overstating what he said, but I don't think it's fair to say that decision stands for the proposition that all educational or all research uses are fair or lawful. And I think it's also about a very narrow type of software and a very specific set of circumstances. On the issue of no evidence of harm, I would say the current exemption is limited to on-premises use. So for us to have the evidence of harm caused by off-premises use, we would necessarily have to be pointing to people who are not covered by the existing exemption. It's also quite difficult to build a record of who believes they're using an exemption and who's engaged in infringement. So collecting that kind of evidence for us is always difficult. On the question about fair use versus Section 108, I would just say that our view is that at least until the Section 108 discussion document gets traction and is passed by Congress, that the Copyright Office should be very hesitant to go beyond the current parameters of the statutory Section 108. And some of what's being discussed today is covered by the recommendations in the discussion document. Some of it, I think, goes beyond what's covered by the discussion document. But the document's been out there for several years. It's not yet been adopted by Congress. So I think it's not necessarily safe to assume that everything covered in that document is covered by Section 107. And that would include covering public performances, which what primarily seems to be at issue here rather than distributions at the request of individual researchers who make requests. As Mr. England reiterated earlier, the current 108E is about user requests, not about proactive projects by universities. Thank you.
Thank you. Dr. Lowood?
Yeah, I just wanted to add a little bit to the comments regarding access and relationship to preservation. Yeah, they're inextricably connected. Indeed, when we apply for grant funding, there is usually a question or two about the provisions of access that we'll provide. And I'd like to add to that that with internal funding, it's the same thing. If within the library, if an internal project is to be considered, we'll have to say something about access. If access is not available to materials that we preserve, it's going to have a chilling effect on those preservation activities.
Thank you, Mr. England. And then I'm going to have one very quick follow-up, and then I'm going to turn it over to my colleague, Mr. Riley, for the next topic.
I'd like to just expand a little bit on Mr. Williams' comments, with which I agree. As the office goes through its fair use analysis here, I think it needs to focus on the broadest possible scope of activity permitted on whatever regulation it is thinking of adopting. And right here, this proceeding in this class now, that is not one that is very limited, as we explored earlier in the panel. And we shouldn't focus on the things that are already permitted by the current exemption. So focusing on the broadest reaches of the new activity that's authorized, what we're talking about is public performance without much in the way of meaningful restrictions, charitably for the convenience of researchers when the audience is researchers, but potentially in the case of public libraries, providing access to their patrons, because that's permitted, for recreational gameplay. And the office has said in 2015 and 2018 that certainly the public recreational gameplay is not a transformative use, not a fair use. And I think it's kind of, there's a tendency by the proponents here to talk about downstream uses like scholarship that could be created if there were more convenient access to preserved materials, but that's really indirect. I think the focus here needs to be public performance for convenience. That's not transformative, and to the extent that we're talking about recreational play by patrons of public libraries, the potential for market harm is very obvious. And with respect to Google Books, I think the Supreme Court's decision could not have been clearer that it was animated by the nature of API declaring code, which at least some justices appear to have thought wasn't protected by copyright at all. And it was within that very specific and narrow framework that reached the fair use decision they did. I think you cannot extrapolate that to all access enhancing uses of public performances of copyright works, creative works. It's just an overreading of Google against Oracle.
Okay, I want to be mindful of time here. Mr. Zambrano, did you have a question?
Yes, thank you so much, Mr. Amir. And this question is for proponents. I'm just curious, in the purposes for off-premises access, we're talking a lot about research and scholarship. Does that include research and scholarship on the preservation methods themselves, or just on the material that is preserved? Thank you.
Dr. Lowood?
Well, I'll try to answer that. Let me know if I'm not answering the question that you're asking. Yeah, well, we do publish on our preservation methods. In fact, the work we've been talking the last few days about the work that we're doing with regard to emulation as a service and some of the things that we've learned, including some of the things that we've learned about our contacts with rights holders in our efforts to gain permission for world access and things like that. So yes, we do engage in research and publish about the preservation methods themselves. Did that answer what you were after? Okay.
Yes, thank you.
Ms. Woodall?
I believe that we're also talking about research on the actual works themselves as a downstream use. As we've discussed, those are treated in practice as a lot of as the same thing a lot of the time. That preservation access for research and teaching. And I'd also like to just add an additional note on the Google decision. I'm not making the point that all teaching and research uses of software or video games are permissible. However, Breyer does list teaching and research as paradigm transformative uses of software. That same principle that software can only be used, the code can only execute so many functions, does apply to video games. This research and teaching is not changing the actual code structure of the video games. We're talking about transforming them for access, critique, comment, that kind of thing.
Thank you. So in the interest of time, I'd like to now turn it over to my colleague, Mr. Riley, who has some questions.
Thank you. I think we've touched on these a little bit, but I want to kind of hammer down on a couple of topics here. For the proponents, I wanted to offer the ability to kind of explain a little bit more and ask whether the claimed adverse effects are clearly attributable to the implementation of a TPM, or are the adverse effects due to changes in the roles of libraries, archives, and museums? And specifically, I know we've made reference to the ability to raise funds and the, for example, the difficulties going to different locations to complete research. Long and short, is this the kind of harm that's related to the TPM? Thanks. Tyler?
Yeah, so I want to be crystal clear that the adverse effects here arise directly from the outcome of the 2018 rulemaking. So the net effect of the exemption in 2018 was to allow permissible uses, but only to allow them on site. That barrier is really significant in preventing a lot of other lawful uses for scholarship and teaching that could be carried out but for that language in the existing exemption. If exemption language doesn't count as an adverse effect of the TPM that should be addressed in this rulemaking, then it's not clear to me where you could ever address adverse effect of the language itself, because those harms that are preventing these lawful uses came about directly because of that language that was put in 3 years ago.
Mr. Band?
But I think the example that Dr. Ruberg gave is a perfect example of exactly how it is the TPM that's the problem. You know, it's the TPM that is preventing or the narrowness of the exemption that has been granted to circumvent the TPM that is preventing the Museum of Play from making access to that game available off premises. And so it's a, that is a perfect example, a clear example of how the TPM is having an adverse effect on a research activity.
So let me maybe ask this in a different way. Are there any games that cannot be preserved under the current exemption?
I think again, they can be preserved, but the utility of the preservation is not as robust as it could be, and that ultimately has negative societal effects.
McSallard?
Yeah, to second what Mr. Mand and Mix Tytler said, right? Like the reason we're talking about funding for this kind of work and that being tied to access is to illustrate exactly that connection, right? Between the limiting the sort of outcomes of any circumvention and thus the preservation to on-site use and the inability to be able to kind of do this work more generally. And I will also say, that it's the goal of the 1201 exemption process, as outlined by the statutory factors, has to do with the idea of making them available for teaching, scholarship, et cetera, right? Like, it's not just like, oh, preservation, although that's what we're focused on here. So my point, I think the point I just want to make is the reason we're talking about sort of access to grant funding, et cetera, is to say that the limits to on-site use as limiting the works to only be available for on-site use results in them not getting preserved. And that's the sort of problem that we're sort of aiming squarely at with this round.
Dr. Ruber?
Hi, so I just wanted to speak a little bit to scale. So I think this relates to your question, Mr. Relly, and also to go back to something that Mr. England said. So Mr. England said that when we talk about scholarship, that's actually focusing in some ways on the wrong thing because it is a down the line concern. And I just wanted to clarify that that's actually really not true. So I'm here today representing a very large field. There are hundreds of people like me who hold PhDs, who study video games professionally. There are thousands upon thousands of students learning about this right now. This is arguably the growing area for the study of art and media today. There are whole new college programs that are starting up. There are, I can't even count the number of books and articles coming out every month. So just to clarify, this is not a vision that I'm talking about for down the line. This is the reality that we live in. This is already vibrant, and there is a serious restriction on that public benefit when we cannot access the materials that we need. So just, I think Mr. Relly, just to put that in context, right, of the scale of the kind of thing that we're talking about.
Dr. Lowood?
Yeah, your question, Mr. Ali, about whether there are restrictions on getting preservation done made me think a little bit there, and it's kind of interesting. Actually, there are some potential issues, and I can speak to some projects that are underway right now involving these very complex objects that digital games and other kinds of interactive media represent, especially when you're talking about titles from the 1980s or the 1990s, where people don't exactly remember how everything was put together. It becomes very complicated. I'm thinking of one project where we've had to draw in people who were involved in the original project, located in other places to take, where we really would benefit from having them take a look at what we're doing, help us figure out how to put together the environment in an emulation situation, those kinds of things to get the preservation done. I think that actually there could be situations where preservation would be impacted by not being able to have remote access to the materials.
So in 2018, the office did not propose extending an affiliate archivist exemption, but I think it was our understanding, and maybe can you confirm, or if you want to add a little more, that was not a part of this exemption request.
Yeah, I was only answering the question about from a practical point of view. Don't ask me to say anything about the legal situation, because you're not going to get a correct answer. But I mean, I'm just saying, as a practical matter, there are situations where, starting to encounter them now as we dig into some of our collections, where we need collaboration from people who are historically involved in these in the creation and development of the software to help us, to guide us in putting together the pieces that will make it possible to run the software again. It's not something that I came prepared to talk about. It was entirely prompted by your question.
I completely understand. I know we're kind of running short on time, so I want to go relatively quickly. Mix Tyler and then Mix Albert.
Sure, I'll keep it short. I wanted to highlight two other first highlight a factual consideration, second touch on the affiliate archivist point. So first, under the existing regime, the methods of preservation that are acceptable tend to inure to the benefit of very, very popular works. So the works that are harder to preserve, that are created by studios that would not have the funds to preserve them themselves, games that typically relate to marginalized identity. For instance, I know we mentioned our filings, but the first video game to feature a Black character, Heavyweight Champion, which there are no existing copies of, is the type of work we're talking about here. And those works cannot and will not be preserved unless libraries and public interest organizations step in to save them, because they are fundamentally unpopular and the industry has no interest in preserving them because they weren't very good from a play perspective, but they are very interesting from a historical perspective.
I actually have a question about that particular game, because you had mentioned that in your filings, and I was a little confused because I was under the impression that that game is lost to time now, and also that it needs kind of specific, specialized interfaces to have the game work. So maybe is that is not a typical game that you're like a type, that might be a type of game, but that game specifically you're not looking to preserve? Or
that game specifically, unfortunately, to your point, is impossible to preserve now because all the copies of it appear to have been destroyed. But there are many, many analogous games that have to do with marginalized identity, such as Caper and the Castro, and I'm sure Dr. Ruberg could speak more on this, that are really, really important when we think about how marginalized people are portrayed in media and what that media says about existing culture. Scholarly, rich games that were not popular at the time of their creation haven't been preserved, and there are only a few copies left. Those are the types of works that are really valuable to scholars that we've heard across the scholars we talk to, they're interested in researching on, that they can't right now because there might be one copy in one library somewhere and they can't get the funding to go and see it, or the library doesn't have the funding to preserve it because they can't make it available. So that's a huge problem. Secondly, to touch on your question about affiliate archivists, this exemption does not encompass affiliate archivists. That was meant to change who could do the circumvention and where. The circumvention here would be occurring on site with the same people who are eligible to circumvent under the existing exemption.
Dr. Ruberg, did you have something to add?
Yes, just a quick follow-up to Max Tytler's point. So it is absolutely the case that there are games that are of great cultural importance that may seem to be lost, but in fact, often there are individual copies in people's private collections. So video games, because you know, people are fans of them, they will often in their garage have collections of them. We have an example of this, a kind of personal informal archive at UC Irvine where I work, where someone came to us and said, hey, I've been storing this in my garage in Las Vegas for the last 20 years. There's an amazing array of things that are important for marginalized folks that are not represented in other collections. But we had very little we could do with them. They're now in a storage closet, this amazing resource, because they take specific tech to run and because we don't have the support to be able to share them more widely. So even things that seem obscure, even things that seem lost, there's still the possibility for them to be refound and to be shared and studied through this kind of work.
Mr. Williams, you're going to respond?
Yeah, thank you. So there are titles that are not commercially available that may never become commercially available again. And to some degree, those titles are already covered by the existing exemption if you're dealing with preservation related issues. There are many more titles that I think would also be covered by the proposal here that could very well become available again, even if they are not available today. And we tried in our comments, and ESA set forth a number of examples in their individual comments to show how common that is becoming. And so to revisit the fourth factor analysis under fair use that people focused on earlier, there is certainly a potential market for games that are currently not commercially available. And in many cases, there's an existing market for those games. Even if it's not being filled at the moment, a copyright owner may decide to fill it in any day. So trying to draw that line, I think, is quite difficult between the games that perhaps are not going to be available and that researchers want to get access to or want to preserve, and games that are still in the marketplace, viable properties that are still under copyright. And so when you include the remote access on top of the existing exemptions, that marketplace damage or potential damage becomes a lot clearer than if you retain them in their current form.
So if I can follow up on that, as we were discussing earlier today, there were two kind of examples of what a user might do with a preserved work in terms of how it would be performed or transmitted, and one was emulation, but the other one was controlled screen sharing. I'm wondering if the opponents have less of a concern related to controlled screen sharing, and maybe with respect to the market or other factors. I'm going to hit on Mr. England first, and then Mr. Williams, if you still want to respond to that, leave your hand up.
So I think we haven't actually heard a lot of exactly what the proponents have in mind by controlled screen sharing. I guess to the extent that it implies that a preservation organization knows personally who its audience is, and so is rendering a public performance, but to a known, well-defined constituency, where it's clear to the preservation organization that they are actually bona fide scholars, as opposed to people interested in playing games for recreational purpose. I think that is a different fair use analysis than the one I think the office would need to engage in given the current regulatory language. So I think if you were to write a rule that talked about controlled screen sharing under the circumstance I just described, I think the fair use analysis would look different. Yeah, I think from my perspective, the most important point here, and I want to make sure it doesn't get lost, early in Mr. Riley's questioning of Mr. Band, I think I heard Mr. Band say that there's no preservation that can't happen today under the current exemption, or something to that effect. It really reinforces the point that we aren't talking about a preservation exemption as the office has always understood that. This is about convenience of access. And I think that's just a very different thing for the office to analyze from a fair use perspective than traditional preservation.
Let's see, Ms. Woodall, and then McSalbert.
So to that point, I believe the example of controlled screen sharing was provided in the context of education. So that doesn't really solve the problem for research or other scholarship access issues. And it is different than traditional preservation. Additionally, to the market point that Mr. Williams made a moment ago, while rights holders do have an ability to reissue their work back into the market, into the commercial market, the case law cited in the ESA's argument or briefing, I'm looking at footnote 54, every single one of these cases is dealing with a non-transformative work, so it doesn't necessarily apply. Transformative works, clearly, as we've discussed in our briefings, don't have the same type of market effect that non-transformative uses do. We're talking about research uses, teaching uses that will not supplant the market. Additionally, their cited point about having the exclusive right to determine when to re-release into new markets has since been overruled as of this month. So while rights holders do have some control of when they can re-release into the market, that market share is not absolute. And as the Google court discussed in its opinion earlier this month, these rights are limited. The Congress, when contemplating inserting software and audiovisual works into the Copyright Act, understood that they would be limited by fair use and other restrictions within the Copyright Act. Thanks.
Well, I want to turn it over to McSalbert. I want to add, if McSalbert or anyone else wants to address this, we've made some mentions of the Teach Act, and the Teach Act has some other kind of restrictions in its language, including language that requires mediated instructional activity and accredited quote unquote nonprofit institutions. Are there any restrictions in the Teach Act that might be appropriate for this exemption? And we'll go to McSalbert first.
I think I'll let Mix Tytler take the Teach Act question. I wanted to talk a little bit about the reissue market issue discussion. Mm-hmm. So I think that, as we addressed in our briefing, just to reiterate, reissues of video games, re-releases may be all very well and good for certain players, but they really actually don't solve the problem for research use. I think the most evocative example we found cited was the Baldur's Gate Enhanced Edition, which actually changed two of the characters' sexualities between the original release and the re-release. So, I colloquially have been calling this the Han shot first problem, but that maybe reveals my my media consumption habits. So I think that to the point about sort of when stuff getting re-released on the market, how to draw that line, I think that the line that the Copyright Office has taken in previous versions of this rulemaking works perfectly well here in terms of if it's not available on the first party market, then it doesn't count, it's out of commerce. And I think the reality is that, and Dr. Lowood and Dr. Ruber can talk more about this if they need to, but most the library style access or archival institution access to video games is always going to pale in comparison for a re-release for folks who are interested in play. I don't there has not been, I don't think there's evidence on the record, and I haven't seen any evidence suggesting that users will line up outside their local archive rather than downloading something to their Switch. I think that just isn't something that's, well, even in the context of having access offsite, the reality is that, I might be able to access certain other kinds of copyrighted materials, novels, through my research institution, but I still buy the physical ones because I actually want to read the physical copy, and or that, it's just not it's not in the same market. So I think that I want to make sure that we don't create a line around the reissues that doesn't actually serve the needs of the scholars we're working with, or sort of create some weird sort of after the fact change to what is fundamentally preservation and a fair use. And I'll let Nick Teitler take the TCHAC stuff.
Teitler?
Yes. So I think what I'd like to highlight here is that it's pretty clear that the highly specific standards in the Teach Act limit usability in a degree that's just far too great and ends up chilling a lot of otherwise fair and permissible uses. The Teach Act, unfortunately, is widely regarded as a legislative failure. Professor William Fisher in his Copyright X course describes it that way, and I'm sure Dr. Lowood could elaborate further that because of the very, very specific limitations in place in the law there, people don't rely on it and don't use it even where there might be permissible sharing of materials. So because, as I said earlier, libraries are such risk-averse institutions that are accustomed to copyright compliance regardless, they are well positioned to determine which uses might be permissible here without importing those traditional specific limitations from the Teach Act. And in fact, if we did import them, because libraries are so risk-averse, they probably, as schools have in the Teach Act, would shy away from using the exemption at all and end up, choosing not to engage in activities that might be fair. So I think we have to be really sensitive to the organizations we're talking about here and what their behavior is like in the real world.
Dr. Lowood?
Okay, just a couple of things. First, about commercial reuse, I just wanted to say that the very popular titles that are more likely to be commercially viable, they represent, in terms of the percentage of titles, actually a relatively small percentage of the collection. Many more titles are more like what Professor Ruberg described, things that from 30 years ago that have virtually disappeared. And the point to keep in mind then is it's very unlikely that a title like that is going to be held by more than one or two libraries, maybe, which means that remote access for scholars who are not fortunate enough to be at one of those institutions is very, very important. And again, it's very unlikely that those titles are going to be the kinds of things that a big publisher is going to pick up for a major re-release. And in those cases, they'll be accessible some other way for students and researchers. About the Teach Act, well, of course, under COVID, we spent a lot of time thinking about the Teach Act and what it allowed us to do, and it is the case it wasn't particularly helpful in coming up with clear guidelines about the kinds of questions we were getting as instructors were frantically moving from all face-to-face teaching to all online teaching and trying to figure out how they could do the equivalent of a screening in a course, showing a film or showing a game to a group of students in real time. And we had to make up a lot of stuff as we went along, to be honest. So I don't know that the Teach Act would be particularly helpful in this regard either.
Mr. England, I'm going to call on you next, but as you reply, I'm going to ask another question. There was this assertion by your proponents that there's no evidence of quote unquote arcades claiming archive or library status under the existing exemption. And I'm wondering if you have any evidence of those, that sort of circumstance, in addition to whatever you would like to offer on the current topic.
So several quick points, and then I will respond to that question last. First, I think it should give the office pause that the proponents throughout this hearing have run away from the express specific purpose statutory exemptions. They did at the beginning of this panel when we were talking about Section 108. They've just now done it about Teach Act. Congress has gone through a process and spoken on the propriety of those uses, and the desire on the part of the proponents here seems to be everything's fair use. We don't have to worry about those. But in trying to apply its fair use analysis, I think the office has to be hesitant to go too far beyond the bounds of what Congress has had to say. Everything's transformative, and so I think it's instructive and problematic that the proponents really can't point to anything other than fair use that they think might authorize the kinds of uses they're talking about. Second, I think Mr. Lowood just mentioned, or Dr. Lowood just mentioned that the kinds of titles being preserved are likely to be more obscure titles, not the most prominent popular games. And I've heard similar themes throughout the panel. Unfortunately, the regulation doesn't say that. And at the risk of repeating myself, the office's analysis needs to look at the broadest aspects of the activity permitted here. So you got to assume that the games that we're talking about providing access to are the most popular titles of 3 years ago that may be part of a franchise that has a current edition out of the market now. And through that lens, apply the fair use analysis. And next point, I think I heard Max Tytler say a few minutes ago that the exclusive right of the copyright owner to control reissues was recently repealed, and that came as news to me. I think that was a reference to the Google against Oracle decision. And again, the court in that decision obviously struggled with the perennial question of how to recognize actual versus potential markets, and ultimately credited a jury verdict about the possibility of Oracle's being able to successfully enter the smartphone market. I don't think that tells you very much at all, if anything, about the ability of video game publishers to re-release titles. It's very clear that they can, they do. It's very popular. Next, Dr. Lowood mentioned COVID, and several panelists during the course they've done COVID. I'm not the one to predict what the path of the global pandemic will be, but we all read the newspaper, hear about escalating vaccination rates and so forth. I think it is at least safe to assume that when these regulations go into effect at the end of October, and 3 years from then, when these regulations finally run their course, the COVID situation will look a lot different. And as colleges and universities talk about reopening their campuses in the fall in anticipation of October 28th, the office should be hesitant to attach much weight to COVID. Finally, the question you just asked about, fortunately, I can't decipher my note. What was the question you just asked?
It was about evidence of any
arcades. Yes.
Yes.
So I think the best example I would provide is an organization called the Internet Archive, and we could perhaps debate whether it meets the definition of libraries or archives that the proponents have grudgingly suggested they might be willing to incorporate here. But it has long provided something called the Internet Arcade. You can Google Internet Arcade, you'll find it. It has a collection of older arcade games that are being run in an emulator and available to a public audience. And so it is mostly not console games, I mean, not at all console games, but I think it's a good illustration of the kind of thing that someone who calls themselves an archive could provide to a public audience if you wrote a regulation that says it's okay to provide emulated games to a public audience.
Okay,
I know
so
we're running low on time. Kevin, did we want to?
Yeah, let me
follow up, or-
just we're over time, and I think I just had one sort of follow-up question. It's primarily for the proponents, and you may want to respond to. I think it's related to some points Mr. England made, so you can incorporate those. I mean, so it's true that any sort of statement by the office about what fair use may or may not cover involves some element of prediction, because every case is different and fair use is very fact specific. But I'm wondering if you can give us sort of a case or cases that you think are kind of the most factually similar, that sort of do the most to bolster your contention that that the type of offsite uses you're requesting is covered by fair use. I mean, I understand and I know you've cited cases in your papers, and I know you've mentioned Google versus Oracle today, but to the extent there is a case that is factually similar to what you're describing here, I think that would be helpful for us. Mix Albert.
Sure. So I think I actually may defer to Ms. Woodall on the fair use point, but there were a couple of points Mr. England raised that I wanted to flag. First, I think that it's unkind to say that we grudgingly accepted these restrictions, because the eligibility restrictions actually come from our 2018 software exemption. And I'm not sure the ESA actually even pointed out that they weren't present in the video game exemption. So we were just trying to do make sure that the exemptions were harmonized and that appropriate institutions were taking things on. With regards to the Internet Archive, I see no evidence, the ESA has produced none, nor I think is there any evidence that that the existence of the Internet Archive's games online has anything to do with the 1201 exemption process. I actually don't even know if any of those games involve DRM in the first place, right? So claiming that that is an example of the type of thing that might be allowed by by a sort of broader offsite access, it strikes me as entirely a red herring, because A, it already exists. They didn't need this exemption. B, we don't even know if they're covered by this exemption. And C, I think the point to make is that the actual types of institutions that are looking to these exceptions for guidance are very cautious, as we stressed over and over again. Finally, I just wanted to respond to the COVID point. So I think as Dr. Lowood sort of has pointed out generally, and I think pointed out to us specifically, the reality is that the creation of offline access mechanisms during COVID is not going away. Although COVID may go away, the expectation is that these offline access mechanisms are going to continue to exist. Scholars have become accustomed to the understanding that, like, hey, you could reach out to a librarian and maybe get access to a course type of software. And I think this just goes back to Dr. Ruberg's point earlier, which is like, there's an equity issue here where we're sort of scholars who study video games are actually not able to access works in the same ways that scholars who study other literature. And then I think that, I'll let Ms. Woodall take the fair use question.
Ms. Woodall.
So 2 points. One, first I'd like to respond to Mr. England's earlier point. It was actually me that was discussing the withdrawal and re-release in the market. I was referring to, yes, Oracle and all of the other case law is non-transformative and doesn't necessarily apply to this case. I'm not suggesting that transformative is as it applies to all uses of software. However, in cases where research and teaching reach that level of comedy critique, they can weigh in favor of that. In response to, and then one last point on that, Congress has also said, in addition to providing rights holders with expansive rights, and judges have concurred with this, that the purpose of fair use is to be flexible and should adapt to new unanticipated uses. And the provisions here that are at issue are 30 years plus old. So fair use is flexible and exactly designed for this kind of analysis. As far as a case that's closely analogous, three come to mind. Corellium, and my pardon if you can hear the sirens going by my window. But in Corellium, Corellium developed a product using the iOS, Apple's iOS technology to create online environments for facilitating technology security research. This allows them to access the iOS in order to fulfill these research ends. Additionally, white is very analogous, that online access to lawyers' legal briefings and additional pleadings that provides access, but it does so with a transformative end by adding value, reviewing, selecting, converting, identifying materials to make them available. Research and teaching do very similar things with the available works. They review, select, comment, critique, do very analogous things to that. Last example I can provide just off the top, Sunderman v. CJ Society. Here we had a critical review of an unpublished novel. That was a fair use because it was using the book for scholarship purposes and as a means of preserving. I believe that fully answer your question, but I'm happy to answer a follow-up.
Great, thank you very much. Ms. Albert, I think you'll be the last word.
I will try to be brief. I know we're over time. So I think that the one thing I wanted to say to complement Ms. Woodall's points with regards to the fair use is that, like, yes, there's not a case that says directly something about remote access because the sort of distinction between on-site and off-site access is a process of this procedure. And so the uses in question are fair. And the question goes to the, as Mr. Ban said earlier, the question about market harm. We believe that the reasonable security measures that that libraries are required or archival institutions are required to implement in order to be eligible for this exemption would more than cover the types of concerns raised by the opponents. And so I think that, you know, the question then is like, we've shown the harm of not allowing offsite access to these works. It both harms the preservation and also harms the development of scholarship in this field. You know, and I think it's up to the Copyright Office to make sure that, you know, the rules that are supposed to exist for the purpose of actually allowing, you know, people to use copyrighted works in ways that are consistent with the public benefit and consistent with fair use, do that. So I'll end there. Thank you.
Thank you very much. And thank you all very much. I think this was a really helpful discussion. And so we will adjourn for today, and we will maybe see some of you tomorrow at 10:30. Thanks very much.